number 5, you guys have Lily. In vote number 4, you've got Monty. In vote number 3, he goes by Skeletor. Vote number 2, our assistant trip leader, you guys have Jack. Vote number 1, these guys are on their own. And team, I'd like to introduce our video voter. You've got Josh right here. It's gonna be go. All right, here we are on the banks of the mighty.
Proof positive that I am cool. I don't want to necessarily say that I'm cool because, you know, I'm not really that cool, but I thought you guys might enjoy seeing what I was up to last week. That was my daughter and I's first whitewater trip of last week's trip. We took 2. We had so much fun. Got back to this week's Young Thug trial, and it has been amazing. A smorgasbord. All right, so that was a little video clip from my trip. Good morning, everyone. Thank you for joining us. Good morning, everyone in the chat. We got people here from Philly, people from New York. I think someone said Iowa. It's exciting. So good morning, everyone. Thank you for being here. My name is Lyin Cadillac, aka OG Cadillac, aka Mother of the Decade, and I am an attorney here in Dallas, Texas. I am a litigation attorney. I do real estate related legal work, litigation, planning, whatever, everything. I do everything if it's real estate related. And I love watching trials. So I started watching the Young Thug trial because of the First Amendment issue, using lyrics against someone. It's very interesting to me. And boy, it has been, woo! It's been the best reality television I've ever watched. Amazing. Oh, Red Money here in Michigan. I didn't know that. Eva, it was really fun. It is not that scary. I mean, you have like a helmet and a vest, and it's not that fast. It's not that scary. Yes, cool mom. I am a cool mom. On my second day of the trip, I wore my cool mom t-shirt with my cool mom socks. Okay. So we had a really fun time, man. Canada is beautiful. My daughter is hilarious, and she's fun and easy to travel with, so it was great. I had a great time. Everyone that tuned in last Friday, I appreciate you. I know they had court, but I appreciate you coming in and supporting me, because I was actually like in my hotel room. So I appreciate that. After we hung up on Friday, me and y'all, my daughter and I went whitewater rafting again. So we had so much fun. All right. Then we got right back to work. Well, I got right back to work. She's still on freaking summer vacation. Because of my trip, I started wondering why I wasn't born with a trust fund. I don't know if any of you wonder that, but on a daily, I'm like, why was I not a trust fund baby? Why did I get those parents? Anyhow. All right, so I just want to be on vacation forever, and I feel like if I had a trust fund, I could do that. I love the river. The river is gorgeous. Ugh, I just loved it. Okay. Before we get into this week's motions, hearings, I don't know what you want to call them. Quick couple updates. I cannot believe it is already almost August 13th. Okay. I had started talking about doing a meet and greet like a month ago, kind of on a whim. And now we are like 4 days away from said meet and greet. I'm like, ooh, it's so exciting. Okay. So on the 13th, if you are in Atlanta, I will be going to the courthouse in the afternoon, sometime after my flight lands. I do not believe that we are going to be allowed in 1A. I think we'll have to go to the overflow, is my guess, because I heard the judge ask about someone who had come in the courtroom, and does he have a 22A agreement? And I don't have any agreements. So we'll go to whatever courtroom we're allowed to go to. We will observe the trial. What's really exciting is that Woody comes back on Monday. So if Woody decides to testify, since they're redoing all of Woody, we will get to see Woody. Who, when he came up to this week, reminded me that he is fucking hilarious. I forgot how funny he is. God, he's so funny. Okay, so August 13th, we'll meet in the afternoon at the auxiliary courtroom, or whichever courtroom we're allowed to go to. And then on that evening at 6:30 p.m., we're going to be meeting at the Hudson Grill downtown. Seti Nash and infamous Sylvia will also be there, so please come. I have a big, huge box that I'm mailing today overnight to the hotel, full of goodies for you. Tons of merch, and some new merch that I brought pens so I can sign. So I've got stuff to give away, tons of merch to give away at Hudson Grill, 6:30, August 13th. Okay, then on August 14th, we're going to meet in the morning at the courthouse again. Not at 8 a.m. They could start at 8 a.m. Lauren does not start at 8 a.m. Okay, but we will meet there and then watch court until I have to leave to go to the airport to go home. Okay, so I'm really looking forward to that. Julie, I wish you could be there too. Anyone that can make it, I hope you come. Yeah, BB, I really, like, who'd have thought that I would have planned the meet and greet so perfectly? I mean, who'd have thought all this crap was going on? And quite frankly, I had my money on this judge calling a mistrial, so I really didn't think there was going to be trial. I didn't think we would be meeting at the courthouse, but here we are. And we'll get into that. We're going to get into these orders. We're going to get into everything, okay? Wow, Carmela said she's retired. I'm incredibly jealous. Let's not talk about retirement with me. Okay, more business to get cleared up. I'm just kidding. You can talk about retirement with me. I someday also will retire, hopefully. All right, a little more business to clear up before we go on. I want to say thank you to Tavanda, who sent me these beautiful earrings. Everyone who has joined the membership, thank you to my members. Thank you to everyone who has liked, subscribed, all your super chats, everything. I really appreciate y'all. I have finally earned enough money to buy a good camera. This one, oh, hold on. That does tracking. Okay, I finally have a good camera that does tracking, and I got a better computer, my mic is fixed, and in November I'm going to have a specific space just to YouTube to you. So thanks to you for all your support so that we could do that. I really appreciate it. I appreciate y'all helping me grow this channel. My goal is to have 10,000 subscribers by the end of the year. I'm at like 6,700. So if y'all do not mind sharing, I appreciate it. Okay, next month is my birth month. As a Virgo, I start celebrating on September 1st. I usually get kind of sick of celebrating by September 25th, but the 21st of September is my actual birthday. Okay, so I am going to do a huge campaign in the month of September. We are going to send money to the National Center for Missing and Exploited Children. A few weeks ago, I heard they have done 2 years in a row this We Will Find You campaign with the U.S. Marshals and some others, and they are looking for any of the 37,000 American children who are at risk and on the streets. And by at risk, I mean they came out of a foster home or maybe a jail situation. They're not just Susie from, the suburb. They're at-risk children. This year, 2024, in that operation, they were able to save over 200 children from trafficking. And I just think that's amazing. When I heard about that achievement, I immediately signed up. I am now a $50 a month contributor to the National Center for Missing and Exploited Children. And for my birth month, which starts September 1st, any membership earnings, any super chats, anything y'all send to us, we will be sending 43% of it to this organization. Because I'm turning 43. Okay, so we're not going to start celebrating my birthday yet. But that's coming, so get prepared. Never forget my birthday, September 21st. There's a song about it. Do you remember the 21st night of September? Okay, I promise you I won't sing. Lakeisha says I want to come meet you, but I can't go because of work. Sorry, Lakeisha, that sucks. If you would like merch, we have launched our merch store. I believe there should be a link in the video somewhere. Okay, so you should be able to, on our channel or even in this video, be able to buy merch. Starting September 1st, 43% of the merch is going to go to the National Center for Missing and Exploited Children. So, okay. Yeah, I think this is a very good cause. I think they're doing excellent work, and that is why I decided to support them. All right. Is there any more business? Yes. I just want to quickly let you know, if you're in the Dallas area and you have skin, you should go see Cynthia at Cynthia's Wax and Skincare. She has been my esthetician for a decade. I look amazing. This is about to be 43 right here, y'all. I'll be looking good, thanks to Cynthia. So, tell her Lauren sent you. All right. Now we can get into what happened this week. Oh, guys, I'm back off the wagon. I started drinking soda again. It's terrible. Terrible, but I will sober up again, I promise. All right. So, last week, Saint Nikki Hilton, patron saint of courtroom patience, made a motion to the judge, basically that she's going to be out of town, and the judge approved that. I have since learned where she was out of town with some prosecutors convention or something, and Fonnie Willis won an award there. I don't know for what. I don't pay attention. I don't care. But that's what I heard. So Saint Nikki Hilton is so freaking lucky that she did not have to work this week. Okay, because this was a hard week for the prosecution. Y'all remember this gentleman? Y'all remember him? His name is Melnick. He's Mr. Melnick. He is Kenneth Copeland's lawyer. Remember when Lyin Love pushed him out of this podium with her butt? She just moved him out of the way. You remember that? Okay.
In cahoots or anything along those lines with Mr. Steele or Mr. Sharp or anybody else in the defense team.
All right.
I was here doing what my client had expressed to me, what he wanted to do. And as I said, if it becomes a major issue, I have more than enough documentation to prove that.
Okay. I appreciate that.
Mm-hmm.
It's not an issue at all to this court.
Okay.
All right. Thank you.
All right. That's it?
That's it?
All right.
Okay, Mr. Steele, you had said to us on Friday afternoon that you had a good faith basis for believing that there may have been a conversation you believe during.
Okay, so time out. I love this hoodie. Love it. Love it, love it. That's all. That I just paused so that y'all can know that I love this hoodie. Oh, also I think Doug's hair looks really good. I don't know, that like week off or whatever. He obviously got someone to do his hair, and I like it. I think it looks nice.
The June 10th ex parte in chambers meeting at some point when Judge Glanville was not in the room, but between Ms. Bumpus, who was acting as counsel for the day for Mr. Copeland and Prosecutor Hilton. So can you give me what your basis is for that? And that one contained.
All right, so if I lower the mic, then there's less feedback or echo on the video, but then I forget to raise the mic so you can't hear me. Such a catch-22. Okay, so Melnick didn't actually leave, I guess. He took his bag, but I guess he didn't make it out of the damn courthouse in time. Yeah, that retwist looks great. Okay, so the judge is now asking Steele about his motion that he wrote that the ex parte is inappropriate because there are things missing from the record, I think. So here's Melnick back.
It's both Ms. Hilton's response and then Mr. Melnick's response back that he just read. Is that correct?
Yes.
Okay, that's admitted.
Okay. This is a repeat.
Oh, remember the email? My favorite email that that Melnick wrote to Love, where he said, you know, if you don't think I'm doing what's best for my clients, then you can go F yourself. That's the email that was just admitted to the evidence.
Okay, if we go to Mr. Williams, number 3, can you take a look at this and tell us whether you recognize it, and if yes, what is it?
It's a
Just what that is, we don't have numbers on it. I can just ask what it is that you're intending. I don't know how many things you got handed, but Mr. Melnick.
She just cut them off. She doesn't even use the mic. I mean, Love just pisses me off. She drives me crazy. Okay, so the defense counsel questions Melnick here at this podium, right?
Send it to Ms. Hilton.
I've questioned witness at the podium before like this.
Any allegation that there was some sort of teamwork or conspiracy against the state of Georgia and against your...
Did you hear that? That was the judge sighing. The judge is so over this already. She does not care about this Melnick BS. By this point in time, she's already made up her mind that they're moving forward. So she does. She's not even paying. Look at her. Look at her head. She's not even paying attention.
Client, Mr. Copeland, is that true at all?
It is categorically untrue.
I want to thank you so much. I don't have any other.
Miss Love, do you have questions of Mr. Melnick?
She's so irritated. Miss Love, do you have questions?
Hang on just a second. Okay, hang on. You
Love is about to beat a dead horse.
have questions too? All right, I'll let Mr. Sharp go.
Good morning, everyone. Thank you for joining us today. All right, here comes Shard.
Mr. Melnick, if you're more comfortable taking the witness stand, that's fine, but okay.
I love Shard's suits this week. He's been dressed to the nines.
Mr. Melnick, good morning.
Good morning.
As part of your representation of Mr. Copeland, as part of your representation of Mr. Copeland, yes, sir. Did you also make it known? Did you make your representation known to the defense counsel in this case, specifically myself and Mr. Steele?
I did. Yeah.
Okay. In your dealings with the defense in this case, have myself or Mr. Steele ever gone behind your representation, to your knowledge, and attempted to speak to Mr. Copeland without your knowledge and understanding?
I have.
Okay. All right. That's what Miss Love did, right? So, okay. So now Miss Love tells him, go sit down on the stand. She's actually wearing pants today, which I found interesting. I cannot stand this boring beige color on anyone. All right, so now she treats Melnick, and she talks like she has some kind of smoking gun all the time. She's like, oh, like she just drives me fucking crazy. Here we go.
Showing you what I will mark as State's Exhibit
one copy of.
Okay, so like, one thing Miss Love does this entire week that we've never seen her do before is stops to think. So she'll say something like, right now she said, I'm showing you State's Exhibit 1. So she's like taking time to think, and it drives me nuts. Like the way I mean, at least she's not running her damn mouth, right? But she has to work so hard to think these thoughts through. She is not quick on her feet by any means, which is wild to me because we're lawyers, and so we're trained to be quick on our feet. So
Defendant Williams Exhibit 1 known proffer. And I was provided this by Mr.
She's glitching because she's finally having to do her job. She has to work. She doesn't know what to do.
Williams,
By Mr. Steele.
yes. Could you look at what I've now labeled as State's Exhibit 1 and compare it to what has been admitted as Defendant's Exhibit 1 and tell me whether or not those two documents, State's Exhibit 1, just for the purposes of the record, is a one-page document. Could you tell me whether these two documents contain the content from the same email?
So the content appears to be the same, other than the fact that on the one that you just marked, there what appears to be the seal from the Fulton County, the Atlanta Judicial Circuit.
And in fact, the one that I've marked as State's Exhibit 1 is the actual email that Mr. Steele would have had access to, correct? It's a portion of the actual email chain, given that it has that seal on it.
Very often, if I'm sending an email, I'll just pick up from the last email that I sent to or from that individual. So that may well be. There may have been a prior email, but I mean, if it was between you and I don't remember exactly when it was.
I'm showing you what has, I believe, been marked as Defendant's Exhibit number.
She thought she had a good one there. These don't match. But like, he's like, yeah, it's an excerpt. They don't match because one is like one page of it and one is the whole thing. Oh, she thought she had it, y'all. Okay. So she annoyingly questions Melnick.
Between June of 23 and May of 20, or June of 24. I mean, I can't give you an exact number, but Mr. Copeland has always been in communication with me.
Did you speak with him more than one time?
Yes.
And during your communication with him, did he always have access to your phone?
Always.
Did he appear to always be aware that he could reach out to you at any time?
This is something where we're going to have to, I don't feel comfortable.
I can stop and pull that question all the way back.
All right.
Oh, she can actually pull a question back. She can stop and pull a question all the way back. It's a real changed woman, isn't it? It is like night and day between the Miss Love we saw in front of Glanville and the Love we see in front of this judge.
And the court can decide if the next question is privileged. Did you assure Mr. Copeland?
I'm not going to talk about anything I said to Mr. Copeland. Period. I'm not going to talk about anything that I said to Mr. Copeland.
I love Melnick, guys. I love him so much. I'm not talking about anything.
Based on how you have already testified, is it safe to say Mr. Copeland didn't reach out to you and say anything?
I'm not going to talk about any communication I had with Mr. Copeland.
Look how irritated the judge looks. Look how freaking annoyed she is.
Any idea why Mr. Sharp, who first alerted you that the state was talking to Mr. Copeland?
No.
The judge is so irritated. Look at her. Look at her. Look at her. Look at her. She's looking at the clock. How much longer? of this crap.
Aware of any communications Mr. Copeland made to state as it pertains to your
Freaking like 14 minutes later.
All right, is there any further
Look at her
questions?
face.
Okay, Mr. Melnick, this time you can actually go. All right. All right, let's move on to the next issue. All right. We're done with this, right? Everybody
See, we're
satisfied?
done. We're done with this issue, right? So the judge is done.
without calling unless the court finds it necessary that the lawyer who was
Okay, in just a second. Yes, sir.
I do not accept any proffer by Ms. Love. I've told the court that before that remains.
I love Brian Steele. Why is so Steele? Oof. He said, I do not accept any proffer from Miss Love. I've told the court that before. Like, no. No.
All right.
I'm objecting. She needs to testify, and that's fine.
Don't talk while somebody else is talking. Let him finish. Let me rule. Then you can go ahead.
Never heard that shit out of Glanville, did we? Never heard that out of Glanville. Glanville would let her run everybody over. This judge is like, no ma'am, he will finish first.
I will listen to what your proffer is, because it's really not for Mr. Steele to accept or not. It's for the court to accept or not. Go ahead.
that Mr. Biden, who was earlier president of the court, was on the call that I think Mr. Melvin referenced that he had regarding, he said he was spoken to Mr. Biden about Mr. Copeland and his representation of Mr. Copeland as a witness in this case. Mr. Biden would testify.
Nobody should feel sorry for Ms. Love. 100% of the heat that she's finally receiving, she should have received months and months and months ago. She was allowed to run around like a banshee, like a wild child. She was allowed to control that court, and she acted a fool for 19 months now. So this is hardly anything in comparison to what she deserves. The next 4 days, after this day, the next 3 days are like days of Miss Love trying to talk about evidence that she still has not given copies to the defense. That's not how we do trials in America. We don't do trial by surprise. All right, so do not feel bad for this woman at all. She works for the government and she is cheating. Okay. So next came Kayla Bumpus. And Kayla Bumpus is a terrible witness. I hope she's a better attorney than she is a witness. Let's get into it.
That occurred the morning of June the 10th during the course of your meeting. I believe that was in Chambers. Is that correct? That was combat. Was that meeting in Chambers? Where did that meeting take place?
In Chambers.
In Chambers. And was the ex parte transcript that you read a complete recording of absolutely everything that took place in Chambers that morning?
No.
Could you please tell me, generally, when was there a time during the course of that ex parte meeting when y'all went off of the transcript?
Clarify what you mean by that, when y'all went off.
Was there a break in the proceedings at some point on the morning of June the 10th? Multiple breaks.
Yes.
And during one of those breaks, did you have occasion to speak to Mr. Copeland with someone else, someone from the states, the state present in the room?
Yes.
And when you had that conversation, that was off the record. That was without the transcript being transcribed.
Yes.
Let's clarify who is in the room at this point in time.
Okay. Who is in the room? And again, let me just make clear on this. I only want you to speak about conversations that you had with Mr. Copeland that are not privileged, where, for example, someone from the state was in the room. Do you understand? Okay. When there was a portion of that meeting that was not recorded on transcript. Who was in the room?
Myself, Mr. Copeland, and Simone Hilton.
Who else? If anyone.
I don't know, all the deputies.
But were there deputies in the room as well?
Yes.
Do you remember how many?
4.
Okay. Anyone else other than the deputies and the 3 people you just named?
Investigator Hamilton and maybe another investigator from the state.
Okay. Approximately how long was that?
Hang on a second. Was the court reporter in the room?
I don't know. I don't recall. I can't remember.
And at what point during the meeting did this allegedly occur?
Towards the end.
If you had a copy of the transcript in front of you, could you show me where? Like,
I can get close, Judge.
okay. Do you have a copy for her?
I don't have, does anyone have a copy? I do not have a copy.
Mine just
printed out.
disappeared. I don't know where mine.
Max, do you have one?
Maybe not. Let's get a clean copy.
Okay.
What had just occurred, and then what occurred following? What had just occurred prior to?
What had just occurred was we had been meeting for a really long time, and I needed to go to the bathroom because I was stressed out. And
Okay.
when I went outside in the hallway,
She just said I had to go to the restroom because I was stressed out. I think, yeah, I definitely think K-Way, she kind of lost it. I don't think they were on their way to a mistrial. I don't think this judge was going to call it a mistrial. But Bumpus's this testimony we're hearing is really bad. It's very inconsistent. And Adele, to your point, watch her when she remembers, when she doesn't remember. Look, she remembers very detailed that she had to go to the restroom because she was anxious or stressed out. But then when Love asks her some certain questions, she doesn't remember those. So we'll keep going.
Simone was outside in the hallway, so I guess she didn't want to be in the room with Mr. Copeland while I stepped out. That's all I can think of. So she was outside. She met me in the hallway. And she said,
Okay, hang on before you get into what anybody said. So, y'all are in chambers. Like, paint the picture for me. You're in chambers.
Like, we're not allowed to call other lawyers by their first name in court. Like, even if it's my co-counsel, like I do a lot of work with Aaron Cartwright, right? So if I was talking about Aaron, who's literally like standing next to me, obviously my peer, I have to call him Mr. Cartwright. So when she calls her Simone and then she starts talking about Brian, and it is really bad. And then when she says unalives, like they're on TikTok or YouTube and not in court, ooh, it's cringe.
Chambers, and then and what happens for you to then leave chambers to go to the restroom?
I needed a break.
Okay, and so you leave chambers.
Yes.
And Miss Hilton leaves chambers.
I don't know when she left, because when I left, she was still in there. But when I came from the bathroom, she was in the hallway.
Okay, when you left chambers to go to the restroom, who was in chambers at the time that you left?
Mr. Copeland, the deputies that were with him, about 4, Miss Hilton, the investigators from the DA's office, the judge, and the court reporter.
Okay.
Wait, hold on.
You took a bathroom break.
Yes.
And as far as you know, you left.
She took a bathroom break and she left her client in there with the judge, the prosecutors, and all those other people?
And then you have no idea when or if anybody else left. But when you came back, Miss Hilton was in the hallway.
Yes.
All right. Well, then that's not the part we're talking about.
No. Well, I think it leads up to the part we're talking about, and that interaction with Ms. Hilton may be relevant to where we're about to go.
All right.
Okay.
Could you please describe the exchange you had with Ms. Hilton in the hallway.
So she asked me, I think I get what you're saying. I think I get what you guys are trying to say. And if he's trying to do what I think he's trying to do, then that's not going to work. And I said, well, I don't know what you're referring to, but I guess we can come back in and you can talk to him about it.
Okay, and so when you said you can come back in the room and talk with him about it, was there any further exchange in the hallway?
No.
What happened after that?
We go back in the chambers.
Excuse me, we being you and Miss Hilton.
Me and Miss Hilton.
You go back into the chambers, and then would you say again who was in the chambers when you went back in?
Well, Mr. Copeland had then went to the restroom, so it was just me and Miss Hilton in the chambers, and then they bring him back in.
Did you and Miss, excuse me, I don't mean to cut you off if you hadn't finished.
No, then the same other people.
Okay, when you and Miss Hilton were in the chambers prior to Mr. Copeland returning, did you and Miss Hilton have any further conversation in the chambers?
No.
Okay. When Mr. Copeland...
Hang on. So you and Ms. Hilton go back into chambers. Do you go back? I mean, chambers is... There's an anteroom where the judicial assistant sits. There's a staff attorney's office. There's the judge's office. Where are y'all? The judge's office? Okay, and when you and Ms. Hilton go back to the judge's office, there's nobody else there but the two of you?
And probably the investigators from the state.
You don't remember?
Well, the deputies had to take Mr. Copeland.
Okay, so Mr. Copeland was gone.
Yeah, he was in
Was the court reporter there?
Yeah, she was there.
Was the judge there? If you remember.
I don't remember if he was in
Okay, so you and Ms. Hilton have a private conversation in chambers?
there. No, we don't talk.
Okay, y'all just walk back in, and then what happens?
And then everybody comes back in.
Okay, who's everybody?
The judge, Mr. Copeland, the 4 deputies, the 2 investigators from the state.
Okay, we're just going to take it slowly, step by step, okay?
Okay.
All right.
Okay, what bothers me is nobody asked about the emergency. You remember, they're in there and the judge is asked to step out for an emergency. If I'm Weinstein, I want to know, when did the judge come back in? Why isn't that on the record? Like, those are easy things to show off the record. I think what happened is, I'm pretty sure Bumpus told one set of facts to the defense attorneys, but when it came down to actually facing the person she was accusing and talking in front of the judge, she had a different set of facts. That's what I think happened. I think she told the defense one thing and maybe reality was slightly different.
Those individuals return. Does Judge Glanville return to the chambers?
Yes.
Is the court reporter in the chambers?
Yes.
Okay. When all of these people are in the chambers, what happens next? A step at a time.
Okay.
Simone starts talking to Mr.
Again with the first name.
Copeland about what we talked about in the hallway.
What specifically did Miss Hilton tell Mr. Copeland about what happened in the hallway?
I don't remember what she said at the beginning, because then she says, wait, Judge, can you step out?
Who is the she that says, wait, Judge, can you step out?
Simone Hilton.
Okay,
How you ask the judge to step out of their own damn office? That's like, you come into my office and you say, hey, Lauren, can you step out? No, the fuck I can't. This is my office. You step out. The way that Hilton and Love treated Glanville is just bizarro to me. Crazy.
The judge to step out. At that point, does the judge step out?
Yes.
Does anyone else step out?
I don't remember if the court reporter stepped out, but I know she stopped taking down what we were talking about.
Okay, and she may or may not have remained in the chambers.
Correct.
Okay.
And so at this point, you're saying that the judge is out, you, Ms. Hilton, Mr. Copeland, 4 sheriff's deputies, and 2 DA investigators are in chambers.
Yes, Judge.
Okay.
Okay. Next step. What happens next?
Simone starts to talk to Mr. Copeland about, I guess this is the part about purging yourself and perjury and impeachment.
Okay.
What specifically did Ms. Hilton say about purging himself?
About purging himself once he began to testify that he would purge himself of him being arrested.
Okay. What about perjury did she tell to him? Did Ms. Hilton say to Mr. Copeland?
I think some of this is on the transcript, but she reiterated the fact that pretty much she wanted him to testify. She didn't know what he was going to say, but there was one thing that they know that he didn't do that she would not allow him to testify to.
Okay. What did Ms. Hilton tell Mr. Copeland was the one thing he knew she
All
knew?
right, let's not assume any of this because this is your witness, so don't lead her, okay?
Okay. So, when you say that, what did Ms. Hilton specifically say regarding that?
Well, first, Mr. Copeland said, I can claim all of this. I can claim all of this. I might as well just say I did all of this. And she said, but we know you didn't do all of this. And specifically, we know you did not kill Donovan Thomas. And I will not allow you to get on the stand and say that you killed Donovan Thomas.
And
Okay, so hold on. Let's pull that apart. Woody said, I can just take claim for all of this. And Hilton says, we know you didn't kill Nut. So you can't say that because that's perjury. Okay. If the prosecution knows for a fact that Woody is not the taker of Nut's life, then Hilton is correct. That is not a misstatement. Woody saying, I can take credit for all of this could be Brady evidence. It could be because, it's exculpatory and it could show that these defendants are maybe incorrect defendants. Could be. All of these are coulds. This is not for sure. Now, one thing I do love about the law, and one thing I love about the practice of law, is that we can argue things. Nothing is necessarily black and white. I make one argument one day on behalf of a client to a judge. I can go in front of that same judge the next day and make the opposite argument for a different client. So, arguably, this was Brady evidence that wasn't turned over. But is this the type of evidence, that would end the trial? What I'm thinking now that we're hearing, well, we had heard Bumpus's version on her YouTube, right? And someone said it in the comments. She's using Unalive so she can keep with her YouTube and her TikTok content. So I think, just like Tanya said, she embellished something. She went and said, oh yeah, he said that, he could take credit for it. And I bet she didn't tell Steele and them exactly how she's saying it now. I'm guessing she let them, add some things in there. And she didn't tell the truth publicly. And so now she is on the stand telling the truth, and as the story is unwinding, it's turning out to not be nearly as dramatic or pressing even as we thought it was. So now it's starting to feel like all this 2 months of just complete chaos kind of all falls on her.
When Ms. Hilton said, I will not allow you to get on the stand and say you killed Donovan Thomas, did she say anything else with respect to that?
Pretty much, I was
explaining to Mr. Copeland about independent evidence, because she said if she had any independent evidence to prove that he was lying about anything, she would just use his statement to impeach him. But she would not necessarily press charges against him for perjury. But she said that if he said this one particular thing, which was the unaliving of Donovan Thomas, that...
See, that irritates the shit out of me. That really irritates me. That whole, like, just use the real word, right? And she is in court, and she's an officer of the court, so she should not be using TikTok lingo right now. It's really irritating.
She made me for with perjury. And Mr. Copeland says, well, it's not just about me knowing who killed him, but it's about, I know more about that infinity, and I know something about somebody who's not even on trial.
Okay, I'm going to stop you there a second because there's a lot to unpack, okay? So, do I understand your testimony to be that Miss Hilton said that she would prosecute him if he lied about the killing of Donovan Thomas, but she would not prosecute him if he lied about other things?
Yes.
Let's go back to the infinity, because I didn't catch all of that. What did Mr. Copeland say about the infinity?
He just said, I know something about the infinity that y'all don't know.
And how did Miss Hilton respond to that?
I don't remember, but basically she just like, okay.
Okay. What happened next in that meeting? Oh, can I stop you a second? Had Judge Glanville re-entered the chambers where you were at this point?
No.
Okay. Please continue. What happened after the comment from Mr. Copeland about the infinity?
I think that, she really didn't say anything about it. She just kept moving forward with explaining to him about she wasn't going to go for that lie about the unaliving of Donovan Thomas, but whatever else you lie about, I'll just use it as impeachment. And that conversation went on for about 5 minutes or so, maybe a little bit more, I don't know. At this point, we've been in there for 2 hours. And they gave me a second to talk to Mr. Copeland, and then that was the end.
Okay. Who gave you a second to talk to Mr. Copeland?
I guess Simone.
Did Simone Hilton remain in the room while you spoke to Mr. Copeland?
Yes, but she couldn't hear what we were saying.
And why do you believe she couldn't hear what you were saying?
She couldn't, I know, because we were whispering, and we scooted away from her, and we just kind of whispered in each other's ear.
Okay. Is there anything
so
else
weird
that happened during the course of this meeting where Judge Glanville was not in the room that you haven't told us this morning?
I'm not 100% sure, but I know there's one time where Adrian said something about Judge Closure.
Where, I'm sorry, who?
Adrian Love.
It is so annoying. Oh, look at her. Look at Miss. She did not like hearing her name that way. Okay, but Bumpus is really driving me nuts with this first name BS. Okay, like, it's Miss Love. This is a courtroom. Someone said something to me in the comments about, oh, you shouldn't tell people how to dress. In a courtroom, there is a certain way to dress. There's a certain way to speak. There's a certain way to behave. And you are expected to comply with those expectations, particularly if you are a licensed attorney practicing law. Just saying.
Okay, let's stop just a second, okay? Because I want to make sure we clarify this. I believe your testimony earlier was that Ms. Love was not in the room, at least during this portion of that meeting. Is that correct?
That's correct.
Are you referring to another portion of the meeting that happened that morning?
I don't remember if he stepped out or not. I just remember at one point she said, Judge, close your ears.
I don't remember if who said.
Okay, let's go back.
Yeah, that's very unclear.
We're going to go back and try to clarify.
Okay. Thank you, Money Mindset, for the $1.99 super chat. Thank you so much. Thank you. I love that. I appreciate you. Okay, here we get back to it. Thank you. I know there are professional standards everywhere, but this is the standard in court. And you don't say unalive. I don't care if you're TikTok generation. You're a licensed attorney.
Let me.
Yeah.
All right. So at the beginning of the meeting, it is Judge Glanville, Miss Love, and you,
Yes, Judge.
the court reporter, and then whoever the deputies are. Mr. Copeland is not there. Miss Hilton is not there. Is that correct?
No deputies.
Okay.
They don't come until Mr. Copeland comes.
Okay. So then it is just the judge, Miss Hilton, and you, and the court reporter, correct?
And the investigators.
The DA investigators. Okay. And so is it that portion of the transcript that you're moving to now? Okay. All right.
And
Okay, Ben had
what did
motion. You were
Ms.
right
Love
then.
say?
I just remember her saying something about Judge, close your ears. And I can't remember if he steps out there for a second or not, but that would be the only other time I remember him stepping out.
Did Miss Love, what did Miss Love say after Miss Love said, Judge,
We're going to skip to
to
Shard.
this courtroom 1C?
Yes.
Okay. Did you ever request an ex parte meeting with the judge?
No.
To your knowledge, did Mr. Copeland ever request an ex parte meeting with the judge?
No.
Okay. How did this meeting come about?
I was down here, and when I got here, the courtroom was closed. There was no one here, and so I contacted Mr. Chamberlain, and he came down. He told me to call him when I got in the courthouse. So I called him when I got in the courthouse, and I was right here. And he came down and got me, and took me upstairs.
Okay. Were you ever told why you were going upstairs?
I was never told why I was going upstairs, but once I got upstairs, I thought I was upstairs because that was the only place I could talk to Mr. Copeland.
Okay.
Mm.
At what point did you realize?
I think I missed that when I was watching the other day. So she comes in and they take her upstairs. Now, you know, she came in not knowing anything. You know, Melnick told her, like, withdraw if he does this. Nobody knew she was going to get dragged in this ex parte meeting because these don't really happen very often. It's not something you can prepare for because it's not like something people do. Okay. So she thought that she was coming in to talk to Copeland, her client, and instead they drag her into this meeting. So that's very interesting.
I said you were being made part of an ex parte meeting.
When Brian got up there and said,
When what? I'm sorry. I just.
Brian,
Who's Brian?
Attorney Steele.
Brian, like, you mean Mr. Steele? Oh my gosh, the first name thing is crazy. And I don't care what generation you are. When you go to law school, you learn these things. They teach you how to behave and how to act like a lawyer. So I don't care if social media has these words. Like, we have legal ease. And it doesn't change just because of TikTok. It's crazy. Like, the way she's talking is wild. Someone said something that they're calling it, another CG, welcome, says saying Epstein is the new fad for saying suicide, which is crazy because Epstein did not commit suicide. Don't get me started on my Epstein theories, y'all. Don't get me started. I mean, look, here's the thing with the first names. When I was a child, I was told you call people Mr. and Mrs. To this day, I had this friend growing up, Caroline Hartley. Her mom, Mrs. Hartley, I still call her Mrs. Hartley. Even though she and I could serve on a jury of peers together, she is not my peer. She is my friend's mother. I call her Mrs. Hartley. That is her name, right? So I can't understand why she's calling him Brian and Adrian and Simone. It's crazy.
Okay.
Got up, and that was the first time I really realized that anything had happened because I had been sitting there and I did not realize what was happening.
Where are you? I thought you had just been brought upstairs to Judge Glanville's chambers.
But it was never a time where they said, "Oh, we're about to meet." They literally just start talking. So
Mr. Steele's there?
no, the first time I realized what had happened was when Mr. Steele made his motion in court.
Okay, so You were in chambers with Judge Glanville and Miss Hilton. And Miss Love, correct?
What I'm saying is,
You answered the question that I am asking. You were in chambers with Miss Hilton and the judge. Sorry. There are two different parts to this ex parte. You were in chambers with Miss Love and the judge and a court reporter, and y'all had conversations, correct?
yes,
Okay. And you were aware prior to that morning that this case was being tried, correct?
yes,
Okay. And you were aware that Miss Love was a member of the prosecution team, right?
yes,
And that Judge Glanville was the presiding judge at the time.
yes,
And that there were defense attorneys on the other side of the case, right?
yes.
Okay. And so when you went into the meeting,
Okay, so time out. The judge has just put Kayla on cross-examination. Oh, Kayla, look, I called her by her first name. So the judge just put Bumpus on cross-examination. The judge is clearly irritated about the inconsistency in just this testimony. And so now the judge is cross-examining her to draw out the fact that she didn't do anything about this inconsistency. She didn't say anything. She didn't put it anywhere. Okay. So, the judge is a former lawyer, right? She's an attorney. So here she goes crossing Kayla. Bumpus.
meeting, you could see that there were no defense attorneys present, right?
No, but what I'm saying is, I didn't know I was going into a meeting.
Ma'am, I understand. Answer the question I asked you. You could see at that point in time that there were no defense attorneys present in the chambers, correct?
Yes,
Okay, so at that point in time, you knew this is a meeting with the prosecution and the judge and no defense attorneys, right?
what I'm saying is,
Ma'am, answer the
No, the answer is yes. I did not see any defense attorneys.
question I am asking you.
I didn't realize it was a meeting.
Okay, so at the point when people started talking, let's call it a meeting at that point in time. Okay.
Okay.
And so you knew that the defense attorneys weren't there then, right?
Yes,
Okay. And so you knew it was an ex parte. If you knew the term ex parte. Go
Oh,
ahead.
the judge just dissed her hard. Obviously, she knows ex parte. She went to law school, right? The judge says, if you knew the term. You can tell Kayla knows, like, I don't know. It's not going to be good to practice in front of this judge very often.
Who initiated the conversation about the purpose of the meeting? Was it you?
no,
Okay, who was it?
All right, let me ask y'all a question. I can read what's in the transcript. So unless there's, something that we're saying occurred before, the court reporter said, okay, I'm ready whenever y'all are. I don't need an exposition of who said what. I can see it, okay?
Okay. I have no further questions.
All right. Ms. Matthews.
Okay. YSL Silver Fox comes up.
good morning.
Just a few questions for you. At any time during the meeting that took place between the court, the prosecutor, yourself, Mr. Copeland, were you ever told by the court not to disclose any of the contents of the meeting?
All right, we are not going to replow the issue of Mr. Steele being held in.
She stopped that right there. Oh, no. No. The difference between a meeting and a hearing. A meeting is like something y'all have at work. Every normal person goes into meetings. A meeting. A hearing is an official event in front of a judge where a judge is going to issue an order. And a hearing has to be noticed. You have to, in Texas, you have to give at least 3-day notice before a hearing, usually 7. So a meeting, that could be impromptu. People could just walk into a meeting. I agree, y'all. This judge is definitely far more pro-government than I am. That's for damn sure. All right, so she stops YSL Silver Fox, and then, of course, Lyin Love gets up.
When you say all of us, who is all of us?
You just asked me do I have any memory of you, Miss Hilton, and Mr. Copeland being in the room? I remember at one point you came back, but I can't remember exactly what happened while you were there.
Is it your recollection that I was there when Mr. Copeland first came into the room?
No.
And when you say you remember that I came back, where is it that you're remembering that I came back to?
Either, I don't remember. Maybe it's when Miss Hilton came back. But at one point, all three of us were in the room.
It is all three of us.
Me, Miss Hilton, and Miss Hilton.
In chambers.
In chambers.
Was Mr. Copeland in the room?
I don't remember. I just said I don't remember.
Well, I mean, it's kind of important. We're relying on your memory for certain things. So, were there deputies?
Okay, remember, she remembered in great detail that she, was feeling stressed and needed to go to the restroom. But now Love is asking her things she doesn't remember. And then the judge says, well, we kind of need your memory. It's kind of the whole point of this exercise, ma'am.
What I'm saying is if Mr. Copeland was ever in the room with Adrian Love, then it wasn't a long, extended amount of time, and I don't think there was any communication. I remember that Simone left, and it was just me, Adrian Love, and the judge and the court reporter.
All right, so your recollection is that at the beginning of the meeting, before Mr. Copeland ever arrived for the first, when he ever arrived with the deputies, that there was a point in time when the judge, Miss Love, Miss Hilton, and you were in chambers?
There was a point in time where Miss Love and Miss Hilton were in chambers with me. I cannot affirmatively state whether Mr. Copeland was there or not, but there was at least 2 minutes of us all being there together.
Did y'all have any conversation at that time?
I can't recall because Miss Hilton was doing all of the talking. I honestly believe it was when Miss Hilton left. At the beginning, when we first got in chambers, when we were in not the judge's office, but all of us were there.
Ante-chambers, like outside the chambers, but inside of the door.
Yes.
Who is all of us?
Simone Hilton, Adrian Love, me, Investigator Hamilton. Mr. Chamberlain was in and out. The judge was in and out talking to us, and that was it.
In and out talking to you about anything substantive?
No, Judge.
Okay. All right, so y'all are all out where the JA, the Judicial Assistant, sits. At first, okay, we'll call that the ante chambers, ANTE chambers. So when is it that any of you go back into Judge Glanville's actual chambers, his office?
Adrian Love says, Judge, can we talk to you for a second in chambers?
Okay, and who goes then?
Just me, her, Adrian Love, and Judge Glanville and the court reporter.
Okay. Go ahead, Ms. Love, if you had anything else.
The judge is so over this. The judge is so over this. All right, so the hearing, the difference between a hearing and a trial. Hearings, you'll receive orders. Those are things to do that lead up to trial. Trial, at the end of trial, you'll have a final judgment. So that's it. Hearings are the decisions on the way to trial. And then trial is the final, here's everything, we're done. Okay. So Miss Love beats the dead horse as per usual.
Hudson, you're not talking about the
case. No, we're talking about the case. She's talking about, I guess she's talking about the reference to me hugging people. I don't know. But we were talking about the case.
Okay, anyway. And then at some point, Miss Love, to your recollection, says, Judge, close your ears because she wants to talk to you about a plea deal.
I don't know exactly I don't remember exactly what she was talking about, but it was something pertaining to the case. And okay, she doesn't want to talk to me about a plea deal because I'm not a defendant.
Right, that wouldn't make any sense.
But she was discussing something pertaining to the case, and she says, "Ooh, Judge, close your ears."
And how long does that conversation go on?
Like two, that's the 2 minutes I'm talking about.
Okay. And then what happens to Miss Love?
She leaves.
She leaves. And then when do y'all go back on the record?
Immediately.
Okay.
Well, no, I talked to Mr. Copeland for a second.
Okay. Privately or? Okay.
Okay. So Leonard, no, there's no
And then y'all go
mistrials
back on
today.
the
It's not
record.
mistrial
And
Monday.
then does the record reflect every?
Okay.
So comment.
The judge does get on Bumpus and says, well, why didn't you tell us that it's not a complete record? And she just kind of, and they let her go. Then they go to lunch. Then they call the investigator.
It's made by Ms. Hilton.
So he's reading the transcript to refresh his memory.
Friday.
Yes, I worked diligently over the weekend on writing an order with regard to that motion. Haven't gotten to the Brady portion of it yet.
So, and I appreciate that, Your Honor. I appreciate the attention that you've given it.
Look, guys, look. I could forget something that happened 18 minutes ago. Okay? Like, her forgetting is not the issue. She is an attorney. She probably has multiple cases, multiple files she's working on a daily basis. There's so much crap inside our little brains, you know. It's not the forgetting that irks me about her testimony. Y'all are right. She knew she was going to be called. She knew she should have known the minute she told Brian Steele that he was going to later call her to talk about it. Secondly, when she did that YouTube on her own YouTube with Woody talking about was the transcript complete, and he's shaking his head and saying, no, you know that. They just added fuel to this fire that really, as it turns out through this testimony, isn't fire. There's nothing that didn't happen on the record. Everything was on the record that needed to be on the record. So it really turned out to be pretty anticlimactic. All right. But I forgot what happened 2 months ago already. I don't even know. I don't even know what month we're in. Are we in August? So it was 2 months ago. June? Yeah, I definitely don't know what happened in June. I would have to go look at my calendar and look at all kinds of things to refresh my memory. I do not remember specific words in conversations, nothing like that. And the reason Bumpus wasn't taking notes is because she didn't know it was going to be a meeting. Like, she came in to talk to Woody, and she was going to sit there and see if he was going to testify or not. That was it. So, you know, there was no reason for her to be taking notes. I'm assuming the prosecution did not take notes because they would not want to be forced to later share those notes with the defense. Particularly based off the actions of this prosecution, I think that's pretty likely. This prosecution likes to not share things with the defense. All right, so on Tuesday, we come in. Lyin Love is wearing that god-awful color on her bottom half. I cannot stand that color. Cannot stand it. But I do like the pink. Okay. All right, let's see what this judge says.
And he can't speak about being at Crucial. I don't have any objections to him speaking about or trying to speak about being at Crucial. I don't have any objections to taking that out.
All right, so are you good with the redaction of 11 line 10 through 12 line 10?
Okay, so on this day, they go through and they piecemeal evidence and what's going to be allowed and what's not allowed. And they're doing those arguments. These are what we call motions in limine. They're supposed to be pre-trial arguments, you know, but this wasn't the judge in the beginning. All right, so here's my issue. Here's my issue. Miss Love just is about to agree to a redaction. Why couldn't she agree to that redaction back when the defense proposed the redaction? Right, just because the other party proposes something doesn't mean you have to always disagree. You don't have to ask the judge for everything. You can agree, oh yeah, you know what, that's probably not going to come in. Okay, we'll redact it. But instead, Miss Love insists on spending taxpayer money on BS to argue about BS that she's willing to agree to. It makes zero sense. It makes me so irritated. This is why I can't do defense work, because I would be so mad. Like, my tax dollars, every time she opened her mouth, I'd be like, give me my money back.
Have you had a chance to look at these proposed redactions yet?
I looked at them. I haven't synced them up with my transcript in my
Okay.
So, because I read the transcript and listened to it so many times,
Okay.
I looked at it now.
Okay.
I haven't synced it up.
Okay, now, so this whole day is just
Okay.
evidentiary hearings.
On the they really didn't care part, are you maintaining that part should come in?
Yes.
Because his observation is that
That they didn't mind. He's offering up an explanation as to why. Basically, the investigator's a little bit incredulous that, wait, you...
right, what's the motive? The motive's just they were hot.
Yes.
All right. Well, if you can establish that he knows that they were on Xanax, then I'll let you use that part. So overruled as to character and sort of like to be determined as to the basis of knowledge on whether they were high or not.
I put subject to foundation.
Okay.
Everything is subject to foundation, by the way. Like, it's stupid that they say that out loud so often. Like, duh.
So the next one is further down. Mr. Zachary is asked by the prosecutor, what was you all's intention when you all headed over there? He says that we were going to kill one of the boys. And then the prosecutor says, and one of the boys, I know we talked about a bunch of names, but which of the guys were you looking for? And then Mr. Zachary responds, the request is to take out 17 through 25 all the way.
Yeah, I think it was 17 through
25.
17 through 20.
Yes.
CJ, I'm going to get to those orders
So
soon.
17 through 20.
First, we're going to get through this.
He's specifically talking about.
See how much
their
struggle?
intentions.
Like, remember, Miss Love used to be able to speak without even pausing or skipping a beat. And she's
They
now
met
just...
on this shooting spree. I think that it's not only relevant, intrinsic, it gives a motive for what they were doing. He has personal knowledge of it. He was in the car. They were riding together.
Okay, well, as long as you establish perjury, that you're lying, then we do intend to charge you, if you know. If you get up and say something that's
Okay.
not...
So, eventually,
Okay.
the judge wants to know if Woody's going to testify on Monday. All right, so the judge then sees if they can get Melnick. Well, I think they get... Did Woody come?
Page 90, line 11 through 90.
So the judge gets Melnick back.
Make sure we clear up a few things and then, find out what his intent is as to whether he's going to testify in this trial or not. We're just essentially going to wipe all of what he already testified to and start over.
Your Honor,
He could be there right now.
Okay. Oh, he's here right now. Okay.
Okay, here we go.
Outside. So,
Here we go.
Do you want to just stand by with us, and if he has any questions?
Sure.
Okay.
and Your Honor, before he's brought in,
Yeah.
I would object to him being asked at this. I'm gonna just talk loud. Your Honor, I would.
I don't know if y'all noticed this, but that squealing on the microphone only happens when Lyin Love is talking. It does not happen to anyone else, just her. I don't know, man. I believe in energy in the universe and all that, and there's something going on to that. There's something to that, I'm sure of it.
Object under all of the circumstances for a number of reasons to him being asked at this point whether or not he is going to testify. There have been he's made statements.
Okay, here we go. Now they've all agreed that if Woody testifies, they're going to start all of his testimony over.
Does it matter because of this immunity order? Or I don't know whether. Go ahead.
Yes, Your Honor.
Okay. All right. And then, are you confident that he has a sufficient understanding of what might subject him to a charge of false statements or perjury?
Certainly he does.
Okay. Anything else y'all can think of on either side of the aisle? Okay.
Yes, Judge, can we inquire as to whether or not Mr. Melnick, and I'm sure he has had an opportunity to discuss with him any potential federal ramifications he may have in regards to his testimony here?
Devon, it's your boo.
And my interpretation of the immunity order is use and derivative use. But, of course, we're not the feds.
And Your Honor, the court has every ability.
See? Y'all, the whole week, every time the mic made that noise, it was only her at the mic. That mic and the podium mic would make that noise. But it's only when she speaks. And I know that's interference, so there's something going on with her.
But I object to counsel for the defense.
I've asked them to raise anything that they think we ought to be thinking about. So, I invited them to say that.
So she just objected.
I don't know whether you want any additional time.
To something the judge wanted.
Potential issue, Mr. Melnick.
Mr. Copeland and I have had enough time to talk.
All right. Okay. Is there a screen where he can actually see Mr. Melnick over there somewhere? Okay. Thank you. All right. Let's go ahead and get Mr. Copeland in.
I think it's bad juju too, y'all. Yeah. For everyone that's just arriving, thank you for being here. I'm Lyin Cadilac, aka OG Cadillac, aka Mother of the Decade. I'm an attorney in Dallas, Texas. I'm a litigator, a courtroom attorney, but I usually focus on real estate, not criminal defense. So I have been watching this trial since it began. And here comes my absolute favorite witness ever.
Hello again, Mr. Copeland. Your attorney, Mr. Melnick, is with us by Zoom right now. You can see him on the video screen, and he can see you. If there's any time you want to talk to him privately, let me know that. And I know y'all have had an opportunity since you and I spoke this morning from the bench of the stand to talk. About the fact that the state is not interested in you pleading the fifth, and in order to avoid you pleading the fifth, they have secured an order that says you now can be essentially compelled to testify, because we are acknowledging that anything that you say, we cannot prosecute you for a crime other than perjury or false statements based on something that you might say that would otherwise incriminate you if it weren't for this immunity order.
I've seen Love wearing the earbud lately.
And if knowing that...
And no, they're not allowed anymore, so I don't know what's up with that.
Not to testify, the court can and will hold you in contempt. And what happens in that event is that you go to jail. And the length of time that you could be held in jail for, if you don't change your mind and say, okay, I guess I will take the stand, is through the end of this trial I don't know how long it's going to last. I think previous projections had been February or March of next year. I don't know yet, but I guess that's not outside the realm of possibility.
Okay. So you remember at that ex parte meeting, Glanville had told Woody that he would be in jail until every single defendant was done being prosecuted. Well, YSL Silver Fox found recent case law that said, no, it's only this trial. So the judge has asked Woody to come back in front of her so she can explain that to him. And that's what she's saying right now. She's like, this trial is going to last until February or March. And if you decide not to testify, that's when you're going to be in jail.
But it would only be through the end of this trial. It would not be through the end of whomever else might be severed from this case and tried later. And I know Mr. Melnick's talked to you in more detail about that. So I want to see if you have any questions of the court about that.
I didn't understand. Now you said it at the beginning.
Didn't understand anything. All right, so...
No, I'm saying, like, I heard you, but I don't know what you're talking about.
Okay, so...
You guys, I forgot how funny Woody is. I'm sorry, Woody just cracks me up. He is so hilarious. He's so hilarious. Miss Love had some weird blue earpiece in, like, a few days later, I noticed it. If she is getting coaching through that earpiece, that coach is fucking terrible and she needs to fire them. That's all I'm going to say about that. Let's go back to the comedy that is Woody.
That you'd like more information about.
You said something about what they said about immunity?
Yeah.
What you mean?
Okay. Does anybody, I think I've got the order. Mr. Melnick, have you reviewed the immunity order with him?
Oh, you said it's the same from last time?
Hang on a second. Yeah, the same one as last time. Yeah, this one. So that's the one I'm talking about. And that is still in effect.
So you're saying that changed?
It has not changed.
All right.
So what has changed is it's my opinion that I cannot hold you in jail if you refuse to testify beyond the end of this trial. I think you had maybe been told something different earlier, and I don't think that is...
So I gotta wait till every defendant is not here.
Correct. But you would, if you choose not to testify despite this order, you would potentially be held in jail through the end of this trial, which might be February of next year, might be March of next year. I really don't know. It ends when it ends. And the state has 100 more witnesses, and I don't know, any defendant might also have witnesses. So it could take a while. But that would be the end of it, would be the end of this trial. Okay? So do you have any other questions? Okay. Do you want to talk to Mr. Melnick any more about this particular issue?
No.
All right, so I'm going to ask you right now because I'm planning to have the jury back on Monday. And I am going to tell them we would essentially start over because I want you to have a voluntary, to an extent, choice. And
to an extent.
choice.
Not really voluntary.
And be questioned and cross-examined or not. Knowing that if you do, other than if you lie, as Mr. Melnick's discussed with you, and it's something the state knows and can prove, they can charge you with perjury or false statements. But they can't, if you say, if you incriminate yourself about another kind of crime, they cannot use that to charge you with a crime. And they can't say, you know.
Well, can I speak?
You can,
I have told the state I have lied and lied and lied.
I know. And,
so how are they going to be able to question me?
I mean, that'll be their problem. That's their case.
That's a great question he asked. It's a really good question.
Is to make or not make. I mean, that's not for you or me to worry about. So
they said they're gonna be able to charge me if I lie. Like when it's up to them to choose.
Not prior. You've said you lied and lied and lied in every. I don't know what you've said, but let's even say you've said you lied in every statement you ever gave to the police. If you get on the stand and say that again, or if you say, all right, this one was the truth, that one they cannot charge you with perjury for, because those are things in the past. What they might be able to charge you with is, I don't know, I mean, give me an example of something that you know he didn't do, and, well, maybe not, never mind, don't do
Can I give you an
that.
example for what they told me?
Yeah, yes, and then I'll see whether that's what I think or not, yes.
She said that the only reason she won't lock me up, I just want to know if it still applies.
Okay.
She said if I do two things, if I plead the fifth, and I say that I killed Donald Thomas.
Okay.
She said if I don't say them two, she will not lock me up.
All right, what was the first one?
Pleading the fifth.
Say it again. Taking the fifth, okay, right. And
She didn't even understand what he...
you can no longer, so taking the fifth means I might say something that gets me in criminal trouble. I might give you evidence against me that you can then use against me. That's what it means to take the fifth, is say, I am not going to give you evidence to use against me to charge me. When they give you that immunity order, immune just basically means we can't do this anymore. It's like if you get an immunization, oh, I'm not going to get the measles now, right? Because I'm immune from it. Because it's like getting you a shot that says, I can admit to a crime on the stand, they can't charge me with it. They have said you no longer have a privilege against self-incrimination because we have committed to not being able to prosecute.
Woody already knows all this, by the way. Like, he is well versed. He knows this. He's just making her repeat it.
You not being able to bring criminal charges against you because of what you say. We cannot take that evidence and use it against you. We can't take that evidence. You know, if you say, well, I committed some crime, here's what I committed it with, I buried it in the yard, they can't go dig it up in the yard and then say, well, we've got this. They can't use any of that. So that's why taking the fifth at this point would get you in trouble. Being held in contempt is what we...
So what if they don't have they facts together? Like, they saying something that they don't know what they're talking about, and then they ask me about it.
They can ask you about anything they want to. If in your answer you admit to a crime, they cannot charge you with that crime. Now, if you admit to a crime and they have evidence that is pretty certain that you did not commit that crime, for instance, somebody gets robbed yesterday, and they have proof that you were in Europe yesterday. There's no way you could have committed that crime, but you say, yeah, I committed that crime yesterday. That was here in Atlanta when they know you were in Europe. And they got a video of you in Europe, and you sent a postcard that said, I'm having fun in Europe. That would be proof that you're lying, and so that they could charge you with perjury for. Okay?
I like this example. I think she did good. This is a good metaphor. It was a very smart metaphor. I liked it, and Woody understood it.
Statements for.
Okay.
Okay? So, what I want to know from you is when we have the jury back on Monday, and you're still under subpoena, so you're still obligated to come, and I'm asking you now, when they're like, all right, we're calling Kenneth Copeland, are you going to say, okay, ask me what you want to ask me, I'll tell you whatever I'm going to tell you, or are you going to say, nope, I don't care if you throw me in jail, I'm not saying a word, I am not getting on the stand?
It depends on how I wake up.
Okay. All right, well then we will just revisit it on Monday morning. So
Depends on how I wake up. Depends on how I wake up. I love Woody. I just think he's friggin' hilarious, guys. Like, depends on how I wake up.
8:45 on.
All right, so he is coming Monday at 8:45. Is there a chance he will plead the fifth? Yes. Now that he only has to be in jail until February or March, it's really not that bad. That's only like, what, 6-7 months? He might take that risk. He really might take that risk. Okay, so that was Tuesday. Now we come to Wednesday. Here's the thing, guys. Red plaid is fabulous November, December, and January. Okay? But in August why are you wearing red plaid? I'm just saying, guys, it's August. It's 850,000 degrees outside. No, Junior, some people go to jail on purpose, so that's not true. Some people will go on jail on purpose. Maybe they need some medical care, some dental care, something like that. They'll go to jail so they can get that care. There are people who would rather be in jail, so that is true. Okay, it is August. What day was this? The 7th. It is 490,000 degrees outside, and she's wearing Christmas plaid. I don't understand it. I don't understand it. David says, we're just going to gloss over Woody, Bumpus, and Investigator Long. All confirmed Hilton coached Woody off the record about what he cannot testify to. We're allowed to do that, so there's no point in even talking about it. We are allowed to prepare witnesses. We're allowed to talk to them about what they're going to testify to. I talk to my clients like, if I ask you this question, what would the answer be? We practice. We practice these things. I don't tell them what to say. That would be a waste of time anyhow, because they'll forget. They'll get nervous on the stand. But we prepare them. We talk to them about what they'll be saying, what's important, what to emphasize. Okay, everyone says the judge has the room so cold. Well, good. I wish my damn room was cold. It's so hot in here. It's killing me. You know, women of a certain age need a certain level of coolness around them. I am of that age, all right? Like, it's hot. I'm internally hot. My friend Emily says that's going to last until I'm like 60, which is just awful. All right, so here we're going to get into Wednesday. This is not Miss Love's day.
Warrant for his cell phone records is material that have been provided to the defense.
So you say that Mr. Boyer's existence was revealed in the wiretap that the defense has had for a while.
Okay, so I guess there's some wiretap or something, and of some dude who's not even related, and they might use that evidence, and of course they didn't share it with the defense. Also, I don't know if this is now, but soon they're going to talk about the mapping of cell phone data, so like cell phone GPS mapping, and that obviously was not disclosed to the defense. However, Miss Love says, look, like someone got on the stand and we realized we could use this data to kind of help dispute it, so we had this other person create it. And of course the judge is like, well, maybe you could have told the defense when you had the idea. But you know Miss Love didn't want to tell them, because if they created it and it turned out to not help her, then she would have to give it to the defense, and she doesn't want to do that. Okay. Monday is going to be really interesting. The jury has so much. Okay, so like the jury, first of all, is going to be like, why do we have a new judge? And then the judge is going to give her little, and then Woody may or may not testify, right? And then the jury is going to be like, holy shit, Miss Love isn't a total bitch anymore. What is going on? Why'd they take my notes away? Oh, it's gonna be so interesting. Oh God, it's crazy. All right, let's get back into it.
His phone number and the number of times he was communicating with Garlington is information that the defense has had for quite some time. Is that right?
Yes.
Okay. When did APD secure anything, and it may have been these cell phone records, that caused them to believe he was in the car with Mr. Nichols?
It was reviewing the wiretap data, which caused them to say, oh, this person looks like he's a part of this.
Okay.
And then looking at the number of times and the types of communication between them, they're able to see data exchanges. They were able to compare it to the time that we believe the murder occurred.
Okay.
And they were able to follow on the surveillance footage that we have the path of.
Okay, so I mean, basically the raw.
Okay, one thing.
Data from which they.
All day on this day, on the Zoom, we could see Love's like body and hand. We can see the back of her head, but we can't see her face, and it drives me nuts because there are some times where I would have really liked to see her facial expression. I would really like, because the judge was getting on her, and I would like to see how she was responding to that.
Reach these conclusions is all from the wiretap?
Yes, it's from the wiretaps, and then when they got the cell phones based on what they saw in the wiretaps during their investigation. And I believe that as it relates to the Waters Road incident that occurred during that same time, they were able to, this is still information in the wiretap, but there was communication from Mr. Boyer about what was going on at the Waters Road incident.
Yes, Tanya. So they have all this wiretap, but they don't give anyone any names.
Okay.
They don't give any specifics.
Have you, meaning the DA's office or APD, conducted any interviews of Mr. Boyer?
No. Not only no interviews, he hasn't, no warrants have been secured either at this time.
All right. I'd like to review the affidavits in support of seeking the. I assume you got cell record, cell site info, and then you separately got contents of cell phone, or did you not need that because you had the wiretap stuff already?
We because no one had any contact with the person himself, we never had access to contents of his cell phone, just his cell phone.
Okay, so when we're saying cell records, it's essentially like location information.
Yes.
Okay. All right. So can you get me the affidavit in support of that, please, to review?
Yeah, guys, there's not going to be
yes,
a
Mr. Sharp.
Your Honor,
okay, here we go.
Regarding the state's assertion that we were put on notice about Mr. Boyer, there is a wiretap. That is true. We were provided the contents of the wiretap. That is also true. There's nothing in the wiretap. There's a phone number, which is what the state handed over on Monday, the contents of that phone number that shows contact through the wiretap. There was nothing linking that phone number to Mr. Boyer. I just want to make that clear. There's nothing that puts us on notice that Mr. Boyer is a person of interest or potentially at all involved or in contact with our clients in this case.
Okay. So,
and there was
basically,
also, Mr. Harvey is also pointing out there was no raw data provided in the wiretap regarding the wiretap itself.
Okay, I guess when I said data, I meant the.
I guess they are really cool because look, Thug has his hands in his shirt. You know, like you used to do in school when you were really, really cold. Look, she's a middle-aged woman. Okay, she needs a cold courtroom. I don't blame her. I don't think there's going to be a mistrial, y'all. This is we're going all the way. We're going to February or March together.
Information from which they formed those conclusions.
I understand. We were aware of what numbers we're calling. What
we
numbers
just weren't aware that whatever this number is was connected. It's obviously somebody's, but y'all didn't know whose phone it was.
And yay, welcome. The reason that affidavit is important is because it's it affirms that the data is true and correct. It's like a business records affidavit, I think is what they were wanting. So
is that they are talking about up to a point at the very least something that Shannon said. I don't disagree that it bleeds into comments about Damikian Garlington, and I'd ask for the court, with respect to the finer points, to give me 1 second.
See her thinking, like, it bothers me. Like, why didn't she sit there and take notes? I don't understand. Also, why are you guys so concerned about her using AI?
2015 interview. Mr. Zachary tells police, and we'll get to that when we address those redactions. He tells the police that he doesn't know what in the world made them do that. And he was
She's like a slow thinker. I do not think the affidavit has come
by
in.
Detective Gaither made what do that? And Mr. Zachary says people who killed him, Shannon, Yak, Nard. And then Mr. Detective Gaither says Nard in jail for kidnapping. Mr. Zachary says, yeah, and Duop. He's then asked what Duop looks like. Then Detective Gaither says, how do you know this? Mr. Zachary says, because they told me. Detective Gaither says, who told you? In August 2015, Quindarius Zachary says, Shannon and Yak told me. Detective Gaither says, why did they tell you that? Mr. Zachary says, we were at the house talking about it. Detective Gaither says, which house? Mr. Zachary says, Thug's house. Question, new or old? Mr. Zachary says, the old one, his condo down there. Detective Gaither says, exactly what did they say? And then from there,
it's a lot of hearsay.
A recitation of events that he says he got from Shannon and Yak. So the argument that this information came from Damikian Garlington, who was just trying to clear his own name, is belied, I think, by the information that the court will hear Mr. Zachary give in 2015.
In Your Honor, I don't dispute that Mr. Zachary has said that Mr. Stillwell, that he's claimed that Mr. Stillwell and Mr. Kendricks made statements to him. That's not the point. And when we deal with those statements, we can address, we'll address those statements in the arguments. But in this particular statement, and we can listen to the tape, my notes say on line 7, Damikian says that they were all in the car. They were all in the car. This information that we're dealing with right now, the source
is from a third party.
Mr. Zachary's own mouth is the source is Damikian. And that's what's on the table before us right now.
All right, we're going to skip to Vonda's boo. Okay, so again, like, a lot of this stuff should and could have been resolved pre-trial if Miss Love would just talk to the defense, right? If Miss Love would ever just acknowledge that there's going to be some evidence that she wants in that's not going to come in, and if she could acknowledge the application of the law. Okay, wait, I thought Shark did great this week. And I'll talk about Atkins when we get to him, because he starts talking. And finally, after 19 months, when Atkins starts talking, all of a sudden I'm like, oh, maybe they were a gang. Miss Love is terrible. 19 months I've been listening to this woman. I never once thought there was a gang. Atkins gets up for a day, and I'm like, ooh. All right, so let's get to Vonda's boo here.
Mr. Garlington said to Mr. Zachary.
All right. Okay, and so for the reasons stated before, I am going to admit those 3 portions of the transcript over objection, is obviously assuming they end up needing to come in, and foundation is otherwise laid.
I do have a motion, and I believe that, or not a motion, but an issue that is in this section, and It's going to it's interspersed throughout both.
Okay.
And when Mr. Zachary testifies, presumably.
Can you talk into your mic?
Yes. So my concern, I understand that I disagree with it, but I understand that Mr. Zachary has claimed that my client made certain confessions to him. I would argue that we need to figure out on my client's behalf what we're doing with the confessions that were made allegedly by Mr. Kendricks to Mr. Zachary, because that is, as I understand the law, I don't see that. Seems like it's spilling the beans.
The statements are alleged co-conspirators,
Right.
which makes them admissible for each of the defendants.
It makes them admissible as long as it is still a statement made in furtherance of the conspiracy. And so y'all are going to need to talk detail to me about when in time and to whom and under what circumstances co-conspirator statements were made, because I can't make a blanket ruling that everybody on trial or everybody indicted, everything they ever said to each other falls under that exception. So let's maybe sit that to the side, but come back to it to the extent I haven't already made a ruling, because it just is going to depend. Okay, so I mean, I don't know, let's just.
Now she's setting stuff to the side. That's so Glanville of her.
Let me add that to my list of things we still need to do, but y'all are going to have to bring to me the detail about what and when and to whom and all of that.
So, Your Honor, that is for sure. That's what we expected. What we were undertaking here is not even an assertion.
Right.
Okay.
Yeah, so we'll do that another time. One other.
Respond to Mr. Sharp's relevance.
I swear he was just like right here.
All right. And
where did Adams go? What happened?
Lines 16 through 21, Miss Love.
What happened? Where did Adams go?
Up to 20. Yes, we don't have any objections to that.
16 through 20.
Okay, hold on.
As I understand the law, I don't see that. Seems like it's spilling the beans. It does not seem like it, and I understand that statements made by Mr. Kendricks, if the jury believes that he made them, can be used against Mr. Kendricks.
Mm-hmm.
They should not be considered against my client, Mr. Stillwell. And I would assume that all the other attorneys who are representing neither Mr. Stillwell nor Mr. Kendricks would have an argument that those statements should not be considered against their clients if they're being admitted as statements by a party opponent.
Okay, now
And
here
for
we
what
go.
it's worth, Judge, if I can just join on behalf of Mr. Williams, I was getting ready to kind of jump in and say the same thing, that I understand the court's pronouncement previously. I understand the state's position as to what they contend those statements are. But in so much as we're charged in this indictment, and we believe that those statements may be admissible against those particular individuals who made them, we do not believe that they're admissible against us. We believe that they do fall under the category of spilling the beans, and that they should not be. They may be admissible against that person, but not against us, and we'd object to those statements being admitted.
All right.
Okay.
Your Honor, if it were that it was, we were only.
And Mr. Copeland was played.
Somewhere, the short gal who sits behind Adams gets up and talks about the state, withholding evidence, and a piece of evidence they withheld said, "Do not release." And I can't find it.
To accomplish that?
Yes, Your Honor.
Okay. All right.
Understood. And agree that's the state's intent with this portion.
Okay.
So Atkins comes back, or starts midday Wednesday, and he does a great job.
Maybe his fled or not, but is indicted.
Much better job than Miss Love.
83, right? Are we back on 82?
I might have had a typo. I had page 82, line 25.
It's 80,
Okay.
83, line 25.
83 line.
Okay. I don't know why Shard was like charged with doing the majority of that work, but he did. All right. So then Friday we came in and Miss Love is again wearing plaid. I guess it's winter in the room, so she thinks she can bring out her winter wardrobe. It's fine. And thank you for your warnings. I'll make sure I bring an extra sweater with me.
Intelligible, do we know what that...
Oh, the do not release was today,
actually
this
said,
day.
or
Okay.
can we listen to that? Because that makes sense.
So Atkins gets up. He's doing all the arguments on this day. Thank goodness, because that voice of love. Oh, I guess she does a little arguing. She's so annoying. We're gonna skip ahead.
Instruction and why we shouldn't give one.
Okay, now they're talking about jury instruction. Bruce Harvey, I noticed on this day that his glasses matched his suit. So I started observing. This man matches his frames to his wardrobe. I love him. He's amazing. He is amazing. His glasses, I mean, a man that is matching his glasses to this, I love it so much. I love it, I love it, I love it, I love it. All right, let's see what he has to say. Oh, her name's Westmoreland. I love her hair.
Yes, my point. And, you know, we just got a potential witness list with exhibit descriptions, which includes the captions impeachment in some of the categories in some of the exhibits. And I know those are potential depending upon what the witness testifies about, but we're clearly in impeachment territory with Mr. Copeland. So I understood Your Honor to say, look, this may be admissible against everybody because they're all charged in count one, and that was the first part of my proposed instruction. That's what I understood you to say yesterday, and I don't really have an argument.
You know what? Thanks for bringing that to my attention, because you're right. I guess, yes, during this exercise,
Yes.
I guess at some points I've been thinking about, okay, substantively speaking, how does this come in? And you're right. If we're thinking about certain of these things as coming in only if they are prior inconsistent statements, then yes, you're absolutely right. So yes, thank you.
Well, that's why it was kind
Okay.
of joined together.
Okay, so I guess thank you for that clarification. And then also what I'm asking is, are you suggesting that I just give this general instruction to the jury, you know, basically whenever we restart the trial on Monday? Or are you saying before each kind of thing comes in,
Well, I don't necessarily know whether you need to do it beforehand. And that was the old rule prior to the new evidence code. And I think the old cases, and they were old cases from like 1990.
Can you try to speak into your mic?
Oh, I'm sorry.
I know it's a lot to do at once.
The old cases were from like 1998, and they said you got to give it beforehand. And you said that yesterday. Boy, I think you got to give it beforehand. And I don't think that's the rule anymore. And I think if you look at the new proposed jury instructions for the Superior Court jury instructions, it says, and I'll quote, note, new code section requires the judge to give limiting instructions when applicable on request.
Okay.
Probably better to give, if applicable, whether requested or not. Now, if witnesses are not impeached by prior inconsistent statements, then it's unnecessary to give it. If they're impeached after, and there's a prior inconsistent statement that may be admissible, I think after that evidence comes in, not before, because you won't know necessarily. You can say, you know, this is admitted as impeachment, and it goes to the credibility of this particular witness. That's my request.
Okay, I think that's a fair request.
That's why it's in 2 phases.
Well, yeah,
Or 2 paragraphs.
yeah, as you proposed it, that's kind of what I'm trying to sort out is they are 2 different topics. Do you want it as just one big instruction, or? And no, I don't think that it's appropriate every time a witness is impeached to say, hey, this might be impeachment, or this is or was impeachment, and here's how you consider it. And not talking necessarily to kind of impeachment evidence, but sometimes there's other evidence that comes in for a limited purpose.
I agree. And I have asked for instructions when I thought, and the state has objected, and they've said, look, it comes in against everybody, and I understand their argument, and I could probably give the opposite, the same argument that I know Ms. Love is going to stand up and give.
Yeah.
But I have asked for those instructions, and when evidence comes in as impeachment, I'm going to ask for the instruction and have it limited to that particular count and that particular person.
Okay, that's fair.
Yeah.
Just as to Mr. Harvey's words regarding
Impeachment evidence,
Okay, so
inconsistent statements
are they talking about Georgia evidence, or are they talking about their own? So then it doesn't matter what federal courts say about it.
But it's the same rule. It's the same rule, and I get it. I conceded that.
So he gave her some federal law
I'm arguing.
on a federal rule that matches a Georgia rule. And he wants her to apply the federal standards to the Georgia law because it is the same rule.
So I think there's some disagreement, but I concede the Georgia rule. But sometimes it's still just impeachment.
Sometimes.
So, and
all he can do is make a record,
said several times,
which is what he's doing.
In their
Sort of background relationship stuff, that's not the murder of Donovan Thomas. That's all the background. So what I'm trying to sort out is, had there been any testimony about the actual, here's the night of the murder stuff before the recusal motion?
So, Judge, it's when you say about, in as much as it's relevant to the issue of the murder itself. That's
okay, right before this hour break.
When we say, okay, I know I told you to disregard it before, but he's available again to testify, so here's what you can consider. The rest of it, we're picking up from wherever. I just think that's the best we can.
All right, let's see. Hey, Alexis, welcome back. Oh, I'm so sorry you got hurt.
Okay.
But I just want you to, because it's going to come up, God forbid there's an appeal. And I don't want the court to feel like we sandbagged you.
Okay. I don't want to feel like that.
So I'm giving a copy of the case, if I may approach.
You may.
Yeah, CJ, it was the self-right evidence, but I don't remember when that was.
That I've given, and it's United States versus Vendetti, VANDETTI 63. That's wrong. 623 F second 1144. It is the Sixth Circuit, 1980, and the copy I've given this honorable court and the state. It's on pages 3 through 4. And then there's another case that I have copies, I have to find them though. It's State versus Thomas, which is THOMAS. and it's 364 Georgia Appeal 148. It's in Division 2. It's 874 Southeast 2D 195. It's 2022, and that's citing to a case that we've all cited a lot. State versus Jefferson, Jefferson, 302 Georgia 435 807.
Yeah, nobody. That's what I thought. I thought she was in the day of the Christmas jacket.
17. The Jefferson case and State versus Thomas deal with a guilty plea of a non-testifying co-indictee in a conspiracy gang case.
That sounds to be a good fit on the case law.
Van Deddy case deals with a jury verdict on a co-indictee who did not testify. The reason I bring this up to you is it won't have any effect on Mr. Sledge because he's testifying, but the state has successfully, over objection, brought in, I'm just remembering Mr. Winfrey, but I'm confident they're going to try to get in Mr. Johnson's client, I can't remember, Eppinger, Eppinger, etc. And I just believe that that's a confrontation clause violation.
All right, and where?
No, this is Miss Love's outfit yesterday. We're watching yesterday right now.
It's in division, on page 3, on the right-hand side.
Okay.
And it starts at the very first full paragraph to determine whether the testimony.
All right.
That's in the Van Deddy case.
Thank you.
No, thank you. And it's a lot of it. They summarize, they in the Sixth Circuit summarize on page 4, specifically the first full paragraph on the left-hand side.
Okay. Thanks.
No, thank you. I just wanted to use the time.
The reason Steele et al. Have been quiet is because it's the prosecution's burden to show and to do all the work here. And this is what the judge got on the prosecution about. Like, why hasn't this work been done?
I think the most challenging one is going to be any sort of a 105-ish limiting instruction on how they are supposed to consider evidence as to the RICO count versus as to the substantive count of the indictment that might be
applied to.
Okay, well.
So we could possibly come up with we could possibly come up with a general charge, but then it would have to be repeated for every overt act for every individual who is not charged.
Now they're talking about jury charges.
With that overt act.
Okay.
Is that fair?
Why don't you give me the really detailed one and then also a more general one? And it may be that even if we don't use the really detailed one now, we use it, you know, at the end of the trial when we're giving them all the instructions. But I'll take a look at both of them. And I know we are going to need to sort of give each other a chance to look at what's been.
Thank you, Kai, for the $1.99 super chat. Thank you so much. I appreciate it. My thoughts on this judge is she's a judge. She is actually doing judge work. She's making decisions as she's supposed to. She seems to be applying the law. There's a lot that we know that she doesn't know. She didn't watch the trial leading up to now. She's only reading transcripts and hearing what people are telling. So, you know, while I don't always agree with her, I do think she's doing a good job. She does actually manage a courtroom. Yes, so I appreciate that. So I think she's doing a decent job. I am surprised she did not call in this trial. But I am starting to believe that's Georgia law and not the judges so much. So thank you so much for your support. Thank you everyone who's here. I'm Lyin Cadilac, aka OG Cadillac, aka Mother of the Decade. I am an attorney in Dallas, Texas. I do mainly real estate, which is heavy litigation, and I love to follow trials. So we are following and recapping this week's YSL trial. Thank you so much for being here.
Are you know?
No, I know that Westmoreland or whatever her name is spoke on. Well, she had white nails the day before. Never mind.
Which maybe can happen in the next hour and a half or 2 hours, maybe can't. But this is finally a good start.
Okay, so she's like, we're finally doing some damn work on this case. The case has been going for 19 months.
Do you need a little bit more time before you send whatever you're going to propose? Okay. Like 30 minutes? Like how long? Okay, so do you two want to huddle together and maybe Mr. Sharp can share with you what he thinks got said, and then you can confirm or...
Yes, would the court give us a moment just to step outside now, or do...
Is this about the coffee shop? This part is about the coffee shop, right?
I don't know what was said.
Okay.
I don't know specifically what was said.
So do you have any reason to believe Brady material or impeachment material was shared then? Or you're just saying they had a meeting and so there may be Brady material that stemmed from it?
There's probably Brady material.
That stemmed from it, but you don't know what it was.
If I knew what the Brady material was,
okay,
then I wouldn't have an issue.
Well, since there, Mr. Sledge's attorney was present at the meeting, so if Mr. Sharp has spoken with him, or I don't know where the idea that there was Brady material, there's no privilege, so Mr. Sledge's attorney is a ready source of everything discussed at the meeting.
All right, maybe would Mr. Sharp, would you be willing to share privately with somebody on the defense? Do you have the same issue with talking to Miss Love that Mr. Steele does?
I don't.
Okay. Would you have an issue with sharing with her maybe the source of your information? And if you do, that's fine, but...
I prefer not to.
Okay. All right. She seems a little in the dark on what might be... I mean...
You know why she wouldn't take notes? Because if there were incriminating evidence, she would have to hand it to the defense. The same reason she didn't want to tell them that they had plotted the cell phone data, because if the cell phone data turned out to help the defense, she would have to turn that over to them if she knew they did it. She did it. So she didn't want to take notes because then there's nothing to hand over.
Not the source, just if he would, just the content, I don't know what he's talking about.
I don't think he does either. Apparently he got some tip that Sledge may have provided Brady material, and that's about all you know, is that right?
If there is anything inconsistent with what Mr. Sledge has signed in his plea agreements or anything or said before, that would be considered impeachment
and therefore Brady. Yes.
Here comes BBL Brown. Uh-oh.
That he may have said something at the coffee shop inconsistent with something he already said. Can you be more detailed with regard to which thing it might be inconsistent to, or you just don't know?
I don't know.
Okay.
And that's why I'm asking.
Okay.
Okay, that's fair.
There were 4 people in the meeting. If anyone's recollection of those set of events are different than mine,
probably
I'd
are.
like to know what they are, because mine is not that he said something inconsistent. And as I said, the people who were there are me, Mr. Sledge, Lieutenant Lancico, and Mr. Sledge's attorney throughout the entire time there. So,
all right. Well, it's really the relevant issue is not who was there. The relevant issue is, did Mr. Sledge say something inconsistent at the coffee shop with whatever he has told the state or law enforcement previously? I guess any of those 4 people could sort that out, the best two would be, well, the best one would be you if you were the prosecutor there, because, I mean, I don't know what else to say. Maybe there's nothing, but maybe if you've got notes, or you and your investigator get back together and think it through and try to figure out whether he said anything that's inconsistent. And, I mean, that's, I don't know what else to do.
This is Thursday, y'all. There's no court today, so we're going over what happened this week.
We will search our collective memory.
Okay.
I am really interested in speaking with Mr. Sharp about what he is talking about, so I can understand where.
All right, I'm not sure he knows.
Different. Somebody has said the word Brady or something, and I don't. I will talk. We will
okay. Something inconsistent.
Did anybody take notes? I mean, so we had 4 people there. Nobody took notes. Nobody recorded.
I don't know that we know that. I don't know.
No, I'm asking. We're entitled to it if that's what happened.
Well, hang on. Mr. Harvey, talk to me. Don't talk across to opposing counsel.
Okay, I have that problem. Sometimes in court, I'll face opposing counsel and start talking to them. You are supposed to address the judge, and then the judge addresses them, even though it's weird because they're standing right there. So that's all that's happening here. Judge says address me and not her.
I'm just somewhat astounded that we had 4 people meet at a coffee shop, and nobody took note number 1.
Mr. Harvey, no one has made that assertion.
Nobody recorded it. I'm asking if there was a report, if there were notes taken, if there was a recording, we would have something to review to determine whether or not
there were Brady.
That
true.
Should be provided to us.
Okay. I don't know whether that happened or not.
And he has every right to feel as passionate about it as he sounds like he does.
Meeting, our conversation, because I would turn that over. I did not record our conversation.
Okay.
It was literally a conversation.
Right.
And that's it.
Okay.
Oh my gosh. Tanya, you are innocent until proven guilty in this country. Those are innocent men sitting in that courtroom, period, end of story. Don't bring that energy into this chat. We are Americans. We are proud Americans. We're innocent until proven guilty. This is a bunch of innocent people sitting in this courtroom. The state has not met their burden. Just because the state decided to prosecute someone does not mean that person did anything wrong. Now, after seeing Atkins' presentation of some of the evidence yesterday, yes, I do believe that a bunch of these gentlemen are in fact guilty. However, the state has not met their burden and shown that to a jury. So therefore, we are looking at innocent men.
So I don't know if Ms. Lowe can speak to what Mr. Sledge or Mr. Sledge's attorney may or may not have done.
I'm asking from the state's obligation to provide it to us. We don't have to go out and talk.
I understand.
All right. So I'm just inquiring as to whether there are any notes, and I'm just surprised.
Okay, Area 51 Beats, you're right. This Georgia is. I'm going there Tuesday. I'll be there Tuesday. I hope to meet y'all, but I'm going home on Wednesday. Oh, Eva, thank you so much, Eva, for the $20 super chat. My God, thank you. It must have been my American pride. Thank you so much. I'm going to Georgia on Tuesday. I am coming home on Wednesday. Do you understand? Because this is not a fair trial. This has not been a fair trial. And from what I can see, the laws of Georgia support this kind of bullshit. So, I'm coming home from Georgia. But yeah, this whole thing has been very un-American, honestly.
Well, I would like an answer as to whether or not any notes
were taken.
Thank you.
2 things. I did not take notes. I talked. Lieutenant Lancico, as she sat there, she looked around and listened and looked around our surroundings. We were not within Fulton County.
Okay. So no notes?
So we're outside of Fulton County, so we didn't have to follow the law.
I would not. Well, there are no notes. I did not take notes. She did not.
Okay.
My notes are not something. My notes, my investigator's notes would be something to which either of the defendants would be entitled. My notes
would be privilege, attorney work product.
Yes.
However, if there's something Brady in your notes, then as you know, you need to provide it. And if there's something Brady that you hear, then you need to reduce it to writing and provide it. We talked about this before, you know that. And so you are maintaining that no, you didn't take any notes, no, your team didn't take any notes. As far as you can think right now, nothing Brady impeaching was said. You will give it some further thought along with your
attorney.
Sure. Okay.
His memory was mine.
That's all we can do at this point. Thank you for raising it so that they can think about it some more.
I gotta be honest, I don't understand my own notes half the time either. Unpopular opinion, to get laws changed, you need to go see your elected officials and start to lobby them for change. You probably want to get a group of people together and have them help you lobby, because the more the merrier. That's it. Get loud in the media. That seems to help. That's all we got.
You asked the state, pursuant to my request, whether there was any Brady whatsoever from any fashion, not only impeachment evidence, but exculpatory evidence. And the state said, let me think about it. This, I believe it was yesterday.
Right.
And I'm presuming by the silence, there's nothing.
All right, so I think I gave y'all, remember I told you to huddle with your team, and not just on Brady, but on anything that is
the judge told them yesterday, you gotta disclose.
That they might not yet have. And I think I gave y'all until Friday to finish that huddle and get that answer back.
So that'll come Friday at 5:45 p.m.
I think there's
we know Miss Love can't do
that,
anything like on time or early or anything.
5 p.m. on Friday, if there is.
So we know that'll be Friday at 4:40 or at 5:49 p.m. And probably she's not gonna do it. I guarantee that Miss Love's gonna hand some stuff over today, of course, and then there's gonna be some revelation 3 weeks from now about some piece of evidence. Well, we didn't know, and the judge is gonna let it in, because we see this judge letting it in. Ridiculous. Okay, let's now go to the orders, or parts of them. I am on X, which used to be Twitter, on Thugger Daily. These are excerpts from the judge's orders. So let's see what Thugger Daily says first. The judge found investigator Long's testimony more credible than that of Bumpus. I did too, quite frankly. When Long said Woody never mentioned the infinity in the off-the-record meeting, judge finds Bumpus likely mixed up her private conversations with Woody and misremembered them and being in front of Hilton. No Brady violation. That's kind of what I thought. Really looked like. Okay, Bumpus claimed Copeland said he knew more about the infinity and someone not currently on trial, but she testified, "You don't know what I didn't know," was the extent of his commenting. She claimed distinct recollections of portions of June 10th and acknowledged lesser recollections of other details. She acknowledged there was time during the meeting when she met and conversed privately with Copeland. She testified that once Hilton and Copeland finished their off-the-record conversation and were rejoined by the predecessor judge and his court reporter, Bumpus consciously endeavored to ensure she immediately placed the record everything about the substance of the off-record. And that's what Bumpus testified. She said, well, it was off the record, so when we got back on the record, I tried to repeat it and make sure that it was on the record. Bumpus never had the record reflect that Copeland had allegedly just revealed to Hilton he had additional knowledge of the infinity and related connection. Long was present in the ex parte meeting from the time Hilton and Copeland joined through the remainder of the meeting, including the off-record conversation. He testified Copeland never said anything about an infinity in Hilton's presence, and he would have remembered. Addition to the testimony, court has considered Bumpus' knowledge as an attorney of her duties to the client and the court, as well as the possibility that Bumpus, who admitted lesser memory for certain portions of the meeting than others, may have confused her private conversation with Copeland and conversations with Copeland and Hilton. Regardless, the court credits the testimony of Long that Copeland did not, in the presence of the prosecution, either state or intimate that he knew more about the infinity, and so no additional Brady material was revealed in this consensual off-the-record meeting. So there's no Brady violation for off-the-record portions. Yeah, it is a lot of drama caused by Bumpus, and I don't think any of her YouTube helped. Like, I don't think her going on YouTube and getting Woody on there helped. I think it fueled a fire. Okay, the judge has ruled on Shard's motion for fair trial. As a remedy, she's sending the entire prosecution to Brady training. That sucks. Stillwell raises numerous assertions of errors, which he asserts have resulted in denial of his constitutional right and fair trial. The determination is whether such events, if they occurred as alleged, warrant a mistrial with prejudice. Okay. What it does provide is cause for sober reflection and examination of processes, procedures, and approaches that permitted this likely inadvertent but nonetheless serious Brady lapse to occur. So here, I don't have the whole order, but the judge found a Brady lapse, but she's not calling a mistrial for it because it's inadvertent. Defendant seeks the sanction of disqualification of the state's two lead prosecutors because this does not appear to the court to have been purposeful, but rather a negligent overlooking of the impeachment value of Copeland's in-chamber statement. The court does not order the disqualification. At the same time, the court is cognizant that the defendant's liberty, as well as the liberty of his co-defendants at this trial, is at stake, and that prosecutors involved are knowledgeable and experienced, and that this is not the first allegation of prosecutorial misconduct in this case. The court therefore orders, as a remedial measure, that the entire prosecution team working at this trial submit to training on Brady and other professional obligations of a prosecutor. Training will consist of a video replay training on this topic previously presented by the Prosecuting Attorneys Council of Georgia. The court will provide the video, and the viewing will occur under the direction of the court. I mean, Cuzzo says, oh, wow, not Brady training, but y'all, that sounds fucking terrible. You have to go into the court, like, chamber and, like, watch a video? Ooh. That means you have to pay attention to the video. Ooh. I don't know. It's kind of torture. Okay, here the judge says, any past failure of the prosecutor to follow orders is a matter of record. Aside from the broad assertion of denial of defendant's right, no specifics establishing this assertion and no claim of resulting legal error. Any potential of error stemming from the failure to follow court orders may be addressed on motion for new trial. Any specious allegations against defense counsel for witness, lack of candor with the court is extremely unfortunate. These do not establish a denial of the defendant's rights. The court reminds all counsel that every Georgia attorney is bound by our rules of professional conduct and owes a duty of candor to the court. These ethical and professional obligations should be scrupulously honored, and prosecutors, above all, should endeavor to comport themselves as to be above reproach on such matters. The court understands that it has the authority to sanction counsel for violation of the rules of professional conduct. The court declines that invitation at present. However, any future or persistent failure to abide by the rules or lack of candor with the court may trigger an extreme sanction of removal. So, no removal. The defense, let's see. does not technically amount to Brady, but it's not a cause for celebration. Okay. That's really it. Here, the judge makes a finding on the ex parte. This must all be in response to Max Shard's motion. And here is the claim that the ex parte is illegal. She says, following a recess, defendant's motion raises several challenges to the ex parte meeting. And did Brady occur? Okay. Did defendant have a right to be present? Defendant is correct that this meeting was about more than just the parameters of Copeland's immunity and whether he understood its potential ramifications. The initial stage of the meeting before the first break entered on the prosecutor's concern whether Copeland's main counsel was laboring under a conflict of interest, blah, blah, blah. The meeting dealt with Copeland's immunity grant and ancillary issues. It was not a critical stage of the trial at which the defendant had a right to be present. And she quotes a U.S. case. Criminal defendant has a right to be present when his presence has a relation reasonably substantial to the fullness of his opportunity to defend himself against the charge, but not when his presence would be useless or its benefit but a shadow. Okay. So it was not a critical stage. Okay. Okay. So the witness understood his deal with the prosecution and he was not unknowingly incriminating himself and understood his constitutional rights held to be an ancillary proceeding dealing only with the rights of the witness. Okay, so I really thought by now there would have been a mistrial. I truly did. But that is not the law in the state of Georgia, unfortunately. Wow. Okay, so we're going to have an exciting day. This evening, we should see Miss Love's submission. Oh, you guys, it's raining. How cool. Okay, sorry. I got distracted. You should see Love's submission of the rest of the evidence. Monday, Woody is going to be there. Well, first Monday morning, they're going to finish the instructions to the jury. Then the jury will show up. The jury is going to have to talk about whether or not they've seen stuff. I'm very interested in how the jury could live in Atlanta and for 2 months not have any information about this trial or hearing come into their purview. That, like, our phones give us local, like, they know, your phone knows where you are. When I was in Canada with my daughter, my phone was giving me like Canadian news, you know. So nope. So we're gonna find out on Monday if the if the jury pool has been tainted. Presumably they're all gonna say no, they didn't have any issues. And then Tuesday we'll continue to move with trial. Monday maybe Woody will testify, maybe not, I don't know. Okay, Weinstein filed a motion yesterday or today. All of those are gonna be heard Monday morning. Tuesday afternoon we'll be at the courthouse. I will be at the courthouse Tuesday afternoon and Wednesday morning, and then Tuesday at 6:30 p.m. we'll be at Hudson Grill downtown. So I hope that y'all will be able to join me there. I really am looking forward to meeting y'all, and just love you guys. You guys are amazing. Okay, thank you so much for being here today. Thank you for your likes. Thank you for the super chats, the Cashapp contributions, your shares, your subscriptions. I really appreciate it. Really appreciate it. If you want to get a hold of me, the email is in the video description. There's also a link to our new merch site. I hope to see you all on Tuesday, August 13th. And I hope you come to Hudson Grill at 6:30 p.m. because I have a bunch of merch I'm shipping out and I want to give it away. Thank you everyone for joining me. I will see you Tuesday, then I will see you again next Friday. Thank you for joining me.